Good afternoon, and thank you for joining today's webinar on work visa options after OPT for F-1 students. My name is Joseph Shepard, and I will be guiding you through today's presentation. First, I want to just note a few items. If you have any questions, you can feel free to use the function to type in your question, and if I can incorporate it into the presentation, I will. Otherwise, I will save time at the end for questions and answers. If we do not get to your question today, you can rest assured we'll get back to you or work it into our next presentation. We will be doing these about once a month for the foreseeable future to give folks a chance to check in and get the latest developments should anything change. Otherwise, the recording will be available on our website for you to watch, and the slides will be available for download afterwards, in case you were worried about taking furious notes while I go through today's presentation. So, to get started, our first topic will be regarding CPT and OPT. The focus of the presentation today will be kind of the life cycle of the progression from F-1 student to OPT post-completion for that first year, then perhaps, if eligible, a STEM extension, otherwise the H-1B cap, and finally what happens if the H-1B cap is met and the petition was not selected. To start off, there are two types of work authorization that we'll speak of before graduation, other than on-campus employment. The curricular practical training is a function that allows individuals to work with other institutions, externships, internships, etc., with employers who have either agreements with the school or some other cooperative arrangement. These days, DSOs have been instructed to require a letter of some sort at least with the cooperating employer stating that it is in fact a cooperative educational agreement or something similar. If you have questions about CPT in particular, your school's international office is a great resource, and perhaps we'll have different guides or resources for you to access. In addition, there is optional practical training. This is available for pre and post completion, but it requires that you have been enrolled in that program for at least, enrolled in that institution for at least a year ahead of time. It has to be in relation to your field or major, and you cannot have more than 90 days of unemployment during the first, I'm getting off track, that's post-completion. Let me back up a little bit. Optional practical training before graduation does not require the actual EAD, but it does in fact require authorization from your school. The I-20 must be endorsed. Post-completion OPT, on the other hand, does require the EAD, and you cannot apply for that EAD until you have the I-20 endorsed from your school. Just very briefly, STEM OPT extension, as we'll talk about shortly, is for those who have enrolled in a program that is on the ICE SEVP list of designated programs. This appears on page 3 of the I-20, and there's a specific field. This is set ahead of time, so can my program potentially fit in this field? It's no gray area. It either is or it is not. And this is something that is set by your school ahead of time, not even necessarily your international office. It's likely something that the registrar's office or similar has handled. So the first thing to do to even see if STEM OPT is an option for you is to check if your program field is on the list of designated STEM fields. If it's not, or if you're considering another program that may provide this additional post-completion extension option. Check that field code ahead of time. The other subset of requirements for STEM OPT require that the employer with which you'll be working is in fact registered with E-Verify. So that is, instead of doing the paper I-9s and ensuring compliance that way, things are completed and filed and available to the government through the online system. It would require a showing to your school and to USCIS that the employer is actually enrolled in E-Verify. Now, unemployment for post-completion OPT. If you have the card in hand, you can begin working. But what if you have the card in hand and you don't yet have a job? Well, you need to be working at least 20 hours a week. If you do not have a job offer, there are perhaps volunteer options at various institutions or similar where you can potentially do this minimum work. Otherwise, if you accrue on 90 days of unemployment on the 12-month OPT regular post-completion, then you can become out of status. And this even applies even if you're out of the country. So even if you went home perhaps for a month or so and you weren't in the U.S., keep that in mind because that does count against you if you're not working in the U.S. You can't work in the U.S. if you're not in the U.S. So for timing considerations, perhaps if there are any students on today's attendees who are maybe in their last year of their program or perhaps the second half of their last year of their program and are coming up on the end of that program. Well, to be able to apply, there's a 5-month window. It's 90 days prior to the program end date, or rather 60 days after. So for individuals who graduated in May, that 60 days has already passed. If you've graduated in very early June, it's likely already passed. But the best thing to remember is apply early and apply. You don't need a specific job offer for the standard 12-month post-completion OPT at the time, but it'd be nice since it takes roughly 90 days or even sometimes more to actually get the card in your hand after you file to apply early so that upon graduation or upon the end of your program, you may have the card or would have the card soon enough. Check with your school for the exact dates to be sure because you don't want to apply too early and you don't want to apply too late. The other consideration is you must apply within 30 days of the school issuing the I-20. That is the date that the I-20, the initial I-20 endorsed for post-completion OPT, was registered as issued in SEVIS. So that does not mean if you asked for it and maybe 20 days have passed and you misplaced it before filing, so then you ask your school to reprint the I-20 for you. A simple reprint of the I-20 is insufficient unless the school specifically corrects in SEVIS the issuance date. So it's important to be very clear what you're asking for with your school's DSO or international office so that you're actually requesting the right document. The I-20 endorsed for OPT must be in the hands of USCIS along with your 765 within those 30 days. So that doesn't mean mail it in 30 days and then it gets there on the 32nd day. That's not good enough. It must be received by USCIS within those 30 days of the issuance date as recorded in SEVIS. So that fun aside, you're working throughout your first year of OPT. You have the card. You're not going out of status because you're not reaching the unemployment levels. and you're coming up perhaps maybe on the 6-month mark or perhaps 8-month mark of your of your OPT. In that case, you want to start thinking about what options are available. The first and most common and prevalent and most widely known is the H-1B specialty occupation visa or classification. This is a work visa option that is employer specific, and it requires a job offer that the minimum requirements for which are at least a bachelor's degree in a specific field of study. The specific field of study, in turn, then you have to show you're qualified for it. So just because it requires a bachelor's degree, period, is not enough. It must require a bachelor's degree in a field where you can show that that's either normal or it's complex or specialized enough. Some examples are potentially, I'm just going to jump ahead to a couple slides here. Wait. Here we go. Back a couple slides. Some examples of specialty occupations, and then you can kind of extrapolate from this the degree requirements. Engineers, computer scientists, graphic designers, accountants, lawyers, financial analysts, in some cases, market research analysts. These are all fields that a degree is either the normal minimum requirements in the industry or, among similarly situated employers, or the Department of Labor specifically says that it is one that usually requires or normally requires this minimum degree. There are then others that are a little bit more of a gray area in terms of field of study that's required. For example, if it is a position such as a paralegal, well, what's the minimum requirement for a general paralegal position? I would say, just based on anecdotal evidence of being in the field for a while, the degree requirement's a bachelor's degree. But what's the specific field of study? Well, it depends on the specific position. The Department of Labor doesn't specify that a bachelor's degree in a specific field of study or, family of fields is required. It depends on the specific position. So if you're working in a paralegal position for a firm that does international corporate compliance or international business transactions or something similar, something with enough specificity where you can show that the degree requirement, for example, the company only hires people with bachelor's degrees in finance, economics, or something similar, one of the business specialties, that then could be a specialty occupation. The company itself has to have this as their minimum requirement. So now that being said, if the company requires a master's degree for a specific position in a specific field of study, you can in turn extrapolate from that a bachelor's degree, it requires at least a bachelor's degree, and in fact it requires more than that. It requires a higher degree. So that's a consideration for folks when looking for the H-1B context, potential H-1B employers or petitioners. Because it is employer specific and job offer specific, it is a process that must be completed and fully from start to finish, ran and run by the company. Throughout the process, the company files a labor condition application with the Department of Labor and agrees to all the regulations and attestations. And the company files the H-1B petition with USCIS. This is not something that the employee is filing. It is the employer who files. So it's very important for the employer to not only be educated about the process, but fully engaged in and in charge of running compliance with the H-1B program. H-1B employment can be full-time or part-time, so it does not have to be a full-time job offer. It can be a part-time job offer. You can have more than one H-1B employer at a time. So if, for example, if you had 2 part-time jobs and those employers were both willing to file the H-1Bs for you, then that's acceptable. There is a 6-year maximum for the H-1B visa that can be extended. It's issued in 3-year increments, but it can be extended past that 6-year maximum in certain situations that we'll get into shortly. Another very important consideration besides that it's at will is that it is employment. H-1B employment means employment, which in turn you can see would be W-2, not 1099. So they must be an employee. They must be able to control and direct the activities of the employee, or if you're a student, you. And in addition, there's also a portability provision, so that in the H-1B cap, which we'll get into momentarily, if after you're selected and counted in the cap with a private employer, and you start working past October 1st, if another employer wants to hire you, either as an additional or a change, you may start working for them upon their filing the H-1B petition for you with USCIS. You don't have to wait for it to be approved. So what that means is if you're working for employer A and you've been working in H-1B status for them from October 1st to December 1st, but you receive another job offer with an employer who's willing to file an H-1B change of employer petition for you, after they go through all the steps necessary, including all the posting provisions and LCA filing certification, and they put the petition together and they file with USCIS by December 20th. As soon as USCIS receives that petition in their hands on December 20th, you may start working for that new employer. It doesn't mean you have to, but you have that option, and you may work for that new employer throughout the adjudication period for up to 240 days, or upon approval, whichever comes first. If it's denied, you have to immediately stop working for them, and you can continue or go back to the old employer, assuming that that other employer A's H-1B petition remains valid. So let's talk about the H-1B cap. There are only, and this is the reason why it's only just one of the options, and it's a somewhat limited, as you'll see. There's only 65,000 H-1B visas available for job offers and individuals who have at least a bachelor's degree. There are even less than that 65 because around 6,000 or 7,000 are set aside for the H-1B1 program, which is a separate visa program, but nonetheless eats up these numbers for individuals from Chile and Singapore who qualify to skip USCIS altogether and can apply for the H-1B1 visas directly at the Department of State with the certified LCA and all the other documents. Now, they're also not subject, those individuals from Chile and Singapore are also not subject to the H-1B cap under the H-1B1 program. They're not precluded from filing or having a petition filed for them on the H-1B cap, but that's a second option for them, and in some cases a better option for them depending on the situation than the H-1B program itself. The cap only applies to private industry employers, so institutions of higher education and research organizations, government research organizations associated with those schools, or nonprofits specifically associated with institutions of higher education are exempt from having to file in this H-1B cap season madness. We call March, similar to the NCAA, March Madness, but in immigration law world, that means that's whenever all the employers are scrambling to file LCAs and get H-1B petitions ready for the April 1st filing date. There's also 20,000 additional H-1B visas set aside for graduates of U.S. institutions of higher education. So the cap opens every year on April 1st. Why? Because that is 6 months, and that's the earliest you can file in advance of a potential start date. At 6 months in advance of the fiscal year, the government fiscal year, which begins on October 1st. So for April 2015, on April 1st, 2015, the fiscal year 2016 H-1B cap opened. And the H-1B cap is required to be opened for at least 5 business days. So regardless of if they receive more than the 65,000 on the first day, they must remain open for 5 business days. So this past cap season, the cap closed on April 7, 2015. It was met much earlier, as we found out. There were, I believe, over 200,000 petitions received during the first 5 business days of April. That did not bode well for many individuals. Around, I believe it was less than a third, or in some cases closer to a fourth, actually were selected in the cap. There were, oh, here are the actual numbers. Fantastic. 36.5 were selected. And, that does not just mean, yay, I win, I get a visa. Now you go through the actual adjudication. For all the other individuals who did not have their petitions selected, in June, we received back the last round of rejection notices. Now, one thing to keep in mind, this year was different from previous years. When USCIS returned the rejected cap petitions, they announced that they had run data capture on all petitions filed, which we can extrapolate to mean likely they scanned or at least did some data entry. It would make sense to scan, but they did not clarify. And each rejected petition notice of non-selection, I should say, it included a specific ID number, similar in style and format to a receipt number. For example, if a H-1B petition was selected, on the receipt notice of selection, and that it's being adjudicated, there is a WAC or EAC number followed by a series of digits. WAC for California Service Center, EAC for Vermont Service Center. For those that were not selected, they received on their notice of non-selection a similar number with 3 letters followed by a series of numbers. So that should mean, for everyone paying attention on it, that USCIS is keeping records of what employers included in petitions for specific individuals. This could be indexed by employer. This could be indexed by beneficiary. Either way, the most conservative, and therefore, what we usually tell our clients, and of course this is not legal advice, and you should not construe it as such, but that USCIS likely has a record of all of these petitions and can go back to them even if they were not selected in the lottery. Now, the actual nuts and bolts of the cap gap. Let's say you're on post-completion OPT this year, and you received your card on June 2nd. Your card is valid from, let's just say, June 2nd to June 1st, 2016. You're working for an employer who in January decides, you know what, it's working out, we really like you, we want to do whatever we can to allow you to continue working in this position. You're doing a great job, you're killing it, etc. So the employer then goes through everything to file the H-1B petition for you. Then they say, well, wait, it looks like your OPT is expiring in June, but you wouldn't be able to start until October. What happens then? Well, there is a specific provision that was put in place around 2009 or so to provide cap gap relief for F-1 students whose EADs expire before the October 1st start date. It allows individuals who are still in F-1 or even during their 60-day grace period, if their F-1 program has ended, if whenever the petition is received by USCIS, when it is physically in the hands of USCIS, if their F-1 or 60-day grace period, if their duration of status is still valid, then their F-1 is automatically extended for the duration of adjudication by operation of law or September 30th, whichever comes first, or denial or notice of non-selection if that comes first. If notice of non-selection occurs after the expiration of the OPT, then the 60-day grace period starts upon notice of non-selection. If the notice of non-selection arrives before your expiration of OPT, then your 60-day grace period starts upon the expiration of your OPT. If your OPT is valid at the time the petition is received by USCIS, your OPT is also automatically extended by operation of law. That is, your employment authorization is automatically extended until adjudication is complete or until September 30th, whichever is earlier, or until notice of non-selection. If notice of non-selection occurs after your OPT expiration date, you must stop working immediately. Now, if your OPT was not valid, let's say that you received your card on March 30th and it expires March 29. Well, then on April 1st, when your employer files the petition for you, what happens is that your F-1, because you're in your 60-day grace period, is automatically extended by operation of law, but your OPT was not valid, so your OPT is not extended. So you do not get to have employment authorization for the summer, basically until October 1st, but you are allowed to physically remain but not work until that October 1st start date. Travel during the summer. Generally, not great, not a great idea. Why? Because let's say you have your I-20 or you have your OPT and it has a certain expiration date on it. If you depart the U.S. while your cap gap extension is active, well, it just may be a hard time, frankly, to convince CBP whenever you come back in that you want to work. It's actually not even that complicated. If you leave the U.S. while your cap gap extension is active, it's an extension. It is not a visa. It does not permit you to come back in. So if you leave the U.S. during a cap gap period, you must remain outside the U.S. until the actual start date, unless you have a valid OPT card that says otherwise. So there are two ways to file an H-1B petition. There is as a extension of status or as a notification for consular processing. You can consular process a visa at any time after it is approved, and you can use the visa to come in no more than 10 days before the intended start date. So if you decide to travel abroad or are already abroad and not availing yourself of the cap gap, then you can pick up the visa usually in July or August upon approval of the petition from USCIS. And then you can use the visa to enter the US as early as September 20th. You cannot work until October 1st. The nuts and bolts of the actual H-1B petition process are employer specific, but here's a general overview just so you know and potentially would be able to help walk through any potential employer who would be willing to sponsor. There are two agencies involved in the H-1B context, the Department of Labor, where first the employer must ensure that their federal employer identification number is validated or verified. Then they must conduct postings in the workplace in 2 conspicuous locations in 2 different places where other similarly situated workers of the company are, to notify them that the company is filing a labor condition application on behalf of a foreign national in a specific position. These postings are not they do not identify the foreign national employee by name, but they do, in fact, correlate to a public disclosure file that the company must keep on the premise that relates to the specific of the job, the wages, the actual wage, required wage, other compliance issues that were beyond the scope of this presentation. It takes at least 7 days to be certified by the Department of Labor. Upon certification, the employer prints 2 certified LCAs, signs both of them, keeps one in the public disclosure file, and gives the other to the foreign national on or before the date they start working. Once you have the certified LCA, so you can see the timing issues, employers must start this process absolutely no later than the middle of March, ideally well before. Upon certification of the LCA, then that is put together with the rest of the documentation for the H-1B petition, and on April 1st, or during one of the 5 business days of April, because it'll be open, they file with the USCIS. Now, I've already gone over some of the obligations, and I'm not going to the responsibilities of the employer. I'm not going to go too deep into them because they're beyond the scope of this. This is about the students, but the employers do have to, and the students / future hopeful H-1B workers should be aware that USCIS does conduct site visits. They do conduct fraud investigations, and they do conduct random site visits. They usually do these for H-1B extensions to ensure that the employer is real. It's not just an accommodation for the foreign national to be able to stay here. They may visit the workplace. They may take photos. They may ask questions. We have an entire series of what to do when this happens, and it's another webinar that will be coming up shortly, I believe in October. So feel free to join on that one. Plug. But they can show up and unannounced, and there's a whole series of steps that we recommend employers take to ensure that these go smoothly when they occur. During the life cycle of an H-1B, since it's a 6-year maximum, plus more if, in certain situations. But during the life of an H-1B, you should expect that one will occur. 1/3 of roughly 1/3 to 1/4 of it, at the last time that they told us how many they were doing, received these random site visits during each life cycle. So imagine 2 extensions, that's a pretty good chance that it's going to happen. So best case is to assume it will. There are specific issues for H-1B employers who are small or startups, or perhaps even if you on OPT started your own business, which is something that is permissible if it's all set up in accordance with the law. But in the H-1B context, self-employment is not permissible. So what does that mean? You can own 100% of the company, but you must be an employee of that company. You must be W-2 payroll. You must have a person or persons that can control, hire, or fire you. So, for example, an independent board of directors, one that you cannot, tell what to do or supersede. If you have 100% ownership but do have an independent board of directors that you as the CEO report to, you may be able to still show that the company qualifies for H-1B. Now, this gets complex and tricky because some sub-regulatory issues are there has to be a physical premise. That's the position that USCIS takes in some of these site visits. Now, you can work from home. You can have a home office. That is something that's permitted, but it has to be a real home office. If they show up and it's just literally a laptop, that might be a little dicey. But if you can show that that's all that's required, that might be okay. Nonetheless, it has to be a real job, and it has to really be done and require a person with this bachelor's degree. So if it's just you and you're the only employee of this company, USCIS might doubt. They may take issue with whether or not you really are, able to perform the specialty occupation. If you also then have to copy, collate, and staple, index, binder, label, instead of doing the duties that require, the analysis and knowledge that stem from a bachelor's degree in a specific field of study. These are just some of the considerations. So we have a typical package that we work with individuals who are going to work for a startup or have a startup that they're interested in working to perhaps have petition for them as an employer for H-1B. So now let's say that, well, maybe my major doesn't qualify for an H-1B, or maybe I didn't get selected in the H-1B cap, or maybe that's just not a possibility given your circumstances. There are perhaps other options for you. They are very specific and very, very, very. I'm not going to say very specific again, but you get the point. The H-1B is built and meant to be the conduit by which individuals who have attained at least a bachelor's degree in a specific field of study can go on to, the professional working world in the U.S. Take into note, though, there are employers that are not subject to the cap. That's the institutions of higher education, the nonprofits that work with them, government research organizations that work with them, etc. There are then also individuals who may become subject to the cap later. If you started working for, let's say, a institute of higher education as a computer programmer, and then get a job offer from a private company, if your H-1B with the Institute of Higher Education was not filed under the cap, if it was filed as a cap-exempt petition, you are subject to the cap to go to a private employer. So you would have to wait for that next round of cap, March Madness, etc., before you can change to that new employer, and you wouldn't be able to start until October 1st. However, the reverse is not true, because there is no madness involved in the cap exempt organization. Once you're counted in the cap, once you start working for them, you're counted. So you then get 6 years at that point. And an important note, time spent outside the US after you started working, can be recaptured. So if you were out of the US an aggregate of, let's say, a year and a half during that 6-year period, and you can document that entry and exit stamps in your passport, flight itineraries, etc. The CBP website has a travel history that is not all the time accurate, so while it's helpful, it is not dispositive. But all these things considered, if you can show that and you can demonstrate that you are eligible for these, you can add on to the 6-year time-wise a year and a half, so that in the aggregate, days inside the U.S. in H-1B status do equal 6 years. Similar to changing employers, the portability option, H-1B extensions are not subject to the cap. Once you're counted, you can change or extend or amend as needed, as long as you do not reach the maximum of 6 years in the aggregate. Let's see, what are some other issues? The two other ways by which you can extend past the 6-year maximum, or rather the standard 6 years. Actually, so once let's say you've exhausted all cap recaptures, you've already exhausted all H-1B recapturing, or maybe you have some left, but it doesn't substantiate really more than a month or anywhere in between. If you also have an employer who has filed an I-140 petition for you, basically the green card process, they have initiated a green card process for you, be it a perm labor certification based one, or perhaps a labor certification exemption for like a national interest waiver, or maybe a Schedule A, or a outstanding researcher, multinational manager, etc. All these different options, right? If you have a green card process that has been pending for more than a year, and you show that by showing your priority date, the date that the perm labor cert was filed or the I-140 was filed, depending on the category, that it's been pending for more than a year, you can extend your H-1B past the 6-year maximum, even in the aggregate, by 1-year increments. It has to remain pending. If, however, you have an I-140 approved, but you can't either adjust status or immigrant visa process abroad because your priority date is not yet current, and that's shown on the Department of State Visa Bulletin, you can extend in 3-year increments past your 6-year aggregate maximum. So those are two important ways. This is called AC21. These are important ways that you can extend past the 6-year maximum, and this is really helpful right now for individuals who are from India or China, because those categories have recently shown to be extremely backlogged or retrogressed, because our immigrant visa system is set up similarly. There's only so many that they can issue per year, and in addition to numerical limitations, they have by country limitations from countries with historically high immigration to the US. So India and China may be backlogged, and they may not have a priority date that's current for a very long time. So maybe sometimes into their 7th or 8th or 10th year of H-1B status in the aggregate. It keeps pushing back the H-1B. So the H-1B is more of a midterm solution. The H-1B visa also, unlike the F visa, is one that allows for dual intent. Specifically, you may travel in and out of the US even if you have a green card petition approved for you, and even if you have an adjustment of status application pending, and if you have an immigrant visa petition filed and pending, and maybe even scheduled for an interview at a consulate abroad, etc. You're allowed to have the long-term intent to remain here. So you do not, in addition, have to show that you have a residence abroad you have no intent of abandoning. In the F-1 student context, you do have to show you have a residence abroad you have no intent of abandoning, and that you do not have immigrant intent. So the F-1 visa is a single intent visa. The H-1B visa is a dual intent visa. The only other explicitly dual intent visa that exists is the L-1, which I might briefly mention if we have time. But there are some that have quasi-intent, we call, because it's not statutory, but it is either regulatory or policy-driven, which we'll get into. And by quasi, we don't mean that you can necessarily have an immigrant visa petition pending or approved or an application for adjustment pending. It just means you don't have to necessarily show you have a residence abroad you have no intent of abandoning. All right. I probably have spent too much time on the H-1Bs, but very briefly for spouses, that last example I mentioned about extending past the 6-year aggregate maximum because of a green card process that is either backlogged or not available due to retrogression. If you are the spouse of an H-1B who now we know can apply for work authorization in certain situations, well, those certain situations are if you have an approved I-140 by the principal H-1B spouse, then the H-4 spouse can apply for work authorization. So that means that if they have an AC-21 extension, if they're eligible for an AC-21 extension, or they have an I-140 petition approved, as you saw in those examples, the H-4 could apply. Now, specifically what that means is if an I-140 petition is approved, you don't necessarily have to show the backlog of the category for the H-4 spouse to apply for the EAD. However, the alternative, if the perm has been pending for a year, or the I-140 has been pending for a year, then that H-1B principal spouse would be eligible for an AC-21 extension. That's whenever the H-4 spouse would be eligible for an EAD. That can be filed concurrently with the AC-21 H-1B extension based on the perm or I-140 pending for over a year, or it can be filed after once that's been approved. The H-4s also may study in the U.S., as have recent rules have been put out about that for F-2 spouses, are now eligible for certain more expansive programs, but an H-4 spouse can study and can work, but only in those two situations. So not all H-4 spouses can work. As you'll see in some of the alternatives to this, there are other categories where the spouse can work, not contingent upon these AC-21 or I-140 contingencies. H-4 children, by the way, cannot work. They're not eligible for EADs. All right, the alternatives to the H-1B. Well, I already mentioned the H-1B ones for Chile and Singapore. These are very similar and almost identical to the E3 for Australians. The E3 for Australians, the H-1B1 for Chile and the H-1B1 for Singapore. These are governed by the same rules involving specialty occupation, job offer, must qualify for it, etc., except for after the Department of Labor certifies the labor condition application. Instead of filing it with USCIS, you file it directly with the U.S. Embassy or Consulate abroad. It does not have to be a U.S. Embassy or Consulate in Chile, Singapore, or Australia. It can be wherever you're residing if you have jurisdiction to be able to apply there. Some posts, U.S. embassies or consulates, do allow third country nationals to apply at those posts, even if they don't live in the district. For example, the U.S. consulate in Tijuana, Mexico, in certain situations, will allow individuals who are already in the U.S. in that status, like E3 or H-1B1, showing that they've already gotten a visa for that status, to come and apply in Tijuana for it. There may be other posts that allow this too, depending on their level of busyness, volume, etc. But that's just one consideration. In addition, if you're in business, let's say in Paris for a short period of time, you may be able to apply as a third country national there to get your visa. However, the rule generally for visa applications is to apply in the place where you last resided or currently reside. But there are some specific posts that will allow it. You can check online with that post. You can contact the post. It may be easier to contact an immigration lawyer who's experienced with these issues. Just be aware that they do exist. The J1 is, there are many different subsets of the international exchange programs. There are some, for example, for primary, secondary teachers. There are some for research scholars, postdocs. There are also J1 visas specifically carved out by nationality. For example, the J1 for Irish nationals. The two that I'm going to talk about today, though, are the trainee and the intern. If you have 5 years of work experience outside the U.S. in the occupation for which the training is going to be in, or you have a post-secondary, that's after high school degree or certificate from a foreign academic institution and 1 year of experience outside the U.S., you may be eligible for a J1 trainee visa. However, if you're in F-1 OPT, you can't really, it's not going to happen. You're not going to be able to change status within the U.S. to a J1 trainee. Why? Because you already have this OPT. You already have this training opportunity. The J1, similar to the H3, H3 explicitly is not set up to just allow you to continue in the same. So for individuals who are foreign graduates, for example, and are not on OPT but are interested in potential visa options in the U.S., may be interested in and may more likely qualify for the trainee or intern. For the intern, you must either have graduated from a foreign institution within the past year or currently be enrolled in such a program. Excuse me. The H3 trainee visa is very similar but has many more requirements. While the J1 is governed by the specific institutions that issue the DS-2019, similar to the schools that issue I-20s, and is run by the SEVIS program through the Department of State instead of ICE, like in the F-1's situation. H3 is governed by USCIS. And an H-3 training program is also not set up to allow you to continue OPT. So you can't change status from F-1 to H-3. You would have to depart the U.S., apply for the H-3 visa, but only after your H-3 petitioner, the employer in the U.S. that will be providing the actual training program, files a petition with USCIS and it's approved. The specifics are even, I think, a little bit more interesting than the J-1, just because the J-1 also has many more institutional delays and issues that may disqualify people in F-1 OPT. The H-3 program specifically and explicitly does not allow for hands-on productive employment, except that which is incidental and necessary to the training program. So what does that mean? Well, you cannot be just doing a job. You cannot be just brought on as another, logistician, or brought on as a even, file clerk. That's not what it is. It can't be just a position that the company is otherwise could hire someone else to do. This has to be more of the supernumerary nature, but more explicitly, you can't just be doing work for the sake of work. It has to be as part of a specific structured program that involves a certain percentage of classroom or lecture, and then a certain amount of supervised hands-on work that is not a direct offering of product or service, but is done for the purpose of the training program. That may sound convoluted, but we do have sample training programs that we put together with folks and or have redacted that are possible, and we work with employers who are going to provide the training to really flesh out the training programs for these. It has to be able to benefit your career advancement abroad. So if you have a job offer from a company abroad, but they want you to go to the U.S. because that training is not available in that country, and you will then go back to that job offer, fantastic. If you don't have a job offer, though, and you want to do a training program in the U.S., you have to show how that skill or knowledge that you'll gain will benefit you in your job search abroad. This can be applied in a multitude of different contexts. First, there's in the corporate sense, right, where affiliate A transfers you for a training program in the U.S. for 8 months or 12 months, and then you'll just go back to your job, which remains open, and you'll be paid by your company abroad for that H-3 training. But then there's the situations where perhaps a certain skill set, computer program or institution-specific or U.S. industry-specific skill is not available. You can't take a training class in it in your home country, for example, because it's just not there. And you're able to get it from the U.S. for this employer. And why will it benefit you in your career abroad? Well, perhaps there's other experts that you, or maybe sometimes your professors or the company that's going to be running the training may have other contacts who are experts in the field and can attest that this will help you in your job search abroad, because this is a very marketable skill to have in your home country, especially for countries that want to do business with or in the U.S. Or already do, and specifically in that industry. So at the end of the H-3 training program, however, you do have to return to your home country. As long as you don't meet the maximum, as long as you don't hit the maximum for H-3, you don't have to go back and remain for a certain period of time. Like the J, where there's many different reasons why you could become subject to a specific 2-year home residency requirement. So as long as the H-3 training program is short enough and you do go back, even if for a month or so, and after that, you may be able to come back to the U.S. to do something else. But the most important thing is you do have to go back. A change of status from H-3 to, say, for example, an H-1B is not going to fly, especially, this is just anecdotally, but especially because if it's the same employer filing for you, it seems kind of odd that the one that said and filed a petition for a training program to help benefit your career advancement abroad wants to hire you in the U.S. There are, of course, situations where things have changed or plans have changed, but nonetheless, you still have to go back, and you still have to go back after the H-2 training program. So it's not, and it does not allow you to remain here continuously in the U.S., and it should not be used to that end. If you have a specific, training objective in the U.S., it is a viable option for individuals who are willing to go back to their home country after F-1, or even folks who've never been on F-1, wait for the petition to be approved, apply for the visa, then come in as in H-3 status. I think we do have a little bit of time, so I will talk a little bit about the L's. So similar in the corporate sense of transferring people to the U.S. for training, you can also corporations can transfer folks to the U.S. For either 5 or 7 years, depending on if it's L-1B or L-1A respectively. If those individuals will be fulfilling a executive or managerial position in the U.S. for L-1A, or a position that involves the application of specialized knowledge gained abroad after a year of qualifying employment within the past 3. That's for L-1B. The requirement of the qualifying employment abroad, the 1 year, does not have to match. So specialized doesn't have to be specialized. Specialized abroad doesn't have to match with a specialized in the U.S. It can be different, but you do have to show that you have that 1 year of qualifying employment abroad with a corporate affiliate, subsidiary, parent, branch, etc. The corporate relationship between the two entities is the most important thing here. Some folks wonder then, well, I've been in the U.S. for 4 years doing a bachelor's program and then a year of OPT, so for 5. I certainly don't have a year of qualifying employment abroad. Well, if you are returning to your home country and do acquire that 1 year of qualifying employment abroad, you may be able to have the U.S. Subsidiary, parent, or corporate affiliate, or whatever it may be, file a petition, an L-1B petition for you to transfer to the U.S. If it's a large corporation that has a blanket certification, you may be able to skip USCIS and apply directly at the embassy or consulate abroad. That being said, for individual petitions filed with USCIS, nonprofit entities are not excluded from this. So if you have an international nonprofit, for example, that has offices in the UK and the US and some other places, an individual can transfer as long as that they have a year of qualifying employment abroad within the past 3, and that's in the aggregate too. So if you do 2 months in the US for some vacation, let's say, you can't use that 2 years as qualifying employment abroad. But you can add up the time within the past 3 where you were with the foreign affiliate and use that for the qualifying employment abroad. I don't want to beat a dead horse, so I'm not going to spend too much time on that. The new office L's are interesting though. So one of the requirements is the U.S. affiliate, subsidiary, branch, etc. has to have been doing business for at least a year. If it hasn't been open for a year, or the company is just now going to open an office in the U.S., you have a qualifying year of employment abroad, and you want to go to the U.S. to work for the company, but if it doesn't meet that 1 year, then it's a new office L, and there are even more stricter requirements for that. In addition, there's only a validity period of 1 year for the new office L to come and open a new office here. After that first year, the company in the U.S. has to file another petition to extend the status. The interesting part about L's, well, there's many interesting parts about L's, but I think most interesting parts are that it is, number 1, a dual intent visa. It is the other one, similar to the H, in that you can travel in and out of the U.S. without having to worry if you have an application for adjustment pending or an immigrant visa application pending, or don't have a residence abroad you have no intent of abandoning. The residence abroad that you have no intent of abandoning is not required for the L-1B context in most situations. There's maybe 1 or 2 exceptions that I won't get into right now. But also, if you have an L-1A manager or executive who had a year of qualifying employment abroad that was executive or managerial, specifically not in this context specialized, then that individual may qualify for a fast-track green card in the EB-1-3 or EB-1C context, which does not involve permanent labor certification and can be filed without any Department of Labor involvement as a multinational manager or a multinational executive in the EB-1 context. That is first preference priority worker category. And by fast track, what do I mean? I just mean you don't have to go through the Department of Labor. There's no premium processing available for the EB-1-3 I-140s, but it does allow you to, since it's first preference, and first preference is usually current, and it is at current, allow you to concurrently file an adjustment of status application, which means 90 days after you file EAD and travel authorization, even though you don't need it since you're already travel authorized. Spouses are eligible for work permits, and they don't have to have any petition pending or something like that. They're eligible as soon as they enter the U.S. in L2 status. Children also get L2 but may not work. In addition, for the entrepreneurs in the audience, there's the E1, E2 treaty trader or treaty investor visas. The treaty traders are for, for example, import exports, where the U.S. trading, the U.S. company trades primarily with the country of the nationality of the same foreign national. The foreign national is, directing all this and working for the company, or the treaty investor, where the investor has put forth and committed a substantial amount of capital into the U.S. treaty enterprise that they either own or they work for a company abroad sharing that nationality that owns and directs the company. And a substantial amount of investment into that enterprise. It depends on the specific industry or what field that company is working in. If you're trying to get an E2 treaty trader, or excuse me, treaty investor visa for an aerospace engineering company, and you share the same nationality as the parent company abroad, well, a substantial amount of capital could mean billions of dollars, billions of dollars. Whereas if the E2 enterprise in the U.S. is, say, a production company or a somewhat other lower overhead kind of industry, it depends on the specific post and the specifics of a case, but ballpark figure in the low end would be around $100,000 or $150,000 of committed investment. Committed doesn't mean $100,000 or $150,000 sitting in a bank account in the name of that entity in the U.S. It means that you've actually spent the money, and you need to have receipts showing how it was spent and committed. For example, you in a physical premise, if you've bought a company, proof of purchase of the company and all assets, etc. If you've been setting up the company for a while or investing into it, into payroll accounts, you can use escrow agreements for treaty investor situations. So money can still be considered committed, even if it's an escrow, subject to the approval of the visa. The ownership must be at least 50% owned by nationals of the same country as the applicant. And of course, there has to be a treaty between the U.S. and the country of the applicant. The startups in this situation are usually most interested in this option. There is a list of available, countries with treaties, either E1 and or E2, available on the Department of State's website. And if you have any questions in that regard, you can first Google to see if there is a treaty, or you can ask a experienced immigration attorney who has knowledge of these issues. I'm also going to just briefly mention that spouses of E1s and E2s, they get E1 and E2 visas as well, but they're dependents. E1, D or E1S, depending on who you ask. But nonetheless, dependents, spouses and qualifying children are eligible for the visas, and spouses can work unrestricted, similar to the L2 spouse. Highly desirable situation rather than the H-1 context, which requires you to at least, now we have it, but requires the H-1B to have either that the approved I-140 or green card process pending for over a year. All right, and my favorite, last but not least, of the non-immigrant visas options in our alphabet soup that we're covered today is the O1 visa. The O1 visa for individuals of extraordinary ability or achievement. O1A is the subset for individuals of extraordinary ability in the sciences, education, business, or athletics. That includes models, fashion models. Even though fashion models should be, in my opinion, considered arts, USCIS takes the position that it is not art. Bummer. But nonetheless, they are governed by the regulations for O1A. O1B arts is extraordinary ability in the arts, and O1B motion picture television, another subset of O1B, is extraordinary achievement in the fields of motion picture TV. Arts, what does that mean? So it could be anything in the performing or visual arts. That includes musicians, graphics designers, art directors, creative directors, artists. Motion picture TV includes and can include actors, writers, cinematographers, directors, producers, etc. So, for example, where would an animator fit in? An animator would fit in under O1B arts. Well, they work on motion picture TV. True, but this is the regulations for O1B arts and O1B motion picture TV, other than being extraordinary ability and achievement, the categories, the specific categories under which you apply, the language is almost identical, but nonetheless, the motion picture TV is set aside for these type of individuals. They need to show extraordinary achievement, not necessarily ability. The O1 criteria I'll get to in a minute, but I just also want to mention while we still have time, and I'm glad that we have so much time, the O2 visas are for individuals who will provide essential support to the O1 or an O1 or many O1s who are in the U.S. That they've had some experience working with before. So, for example, a O1B musician, a singer-songwriter, or an O1B violinist. If the performer in those situations has accompanying musicians who regularly perform with them, and we're not talking about a band where the band itself is the primary performance entity. I'm talking about where it's usually one individual who is the lead and usually billed only by name, yet has these accompanying musicians either during concerts, events, or recordings, etc. Even their sound technicians and similar. If they've had experience with the individual abroad, say they've been on tour with them before, or they've done recordings with them in the past, and we absolutely need them to do it. Like, this is the person who I work with and does all my recordings, or does all of my makeup. That individual then can usually qualify for O2. O2s can be filed all with one petition together, but cannot be filed on the same petition as the O1. So if you have one performer with many support personnel, there's two petitions being filed with USCIS, and if you're doing premium processing, you must do two premium processing checks because they're two separate petitions, even though you bundle them and file them together. The O3 category is for spouses and qualifying children of O1s, and there's unfortunately no work authorization available. I should also mention, by the way, we briefly talked about J's, but there is a J2 spouse and dependent child designation and the J2 spouse is eligible for work authorization. The H3 spouse and child designation is the H4, but there is no work authorization for spouses and children of H3s. Even though H4s can apply, it's only if their spouse is H1. Alphabet soup. To qualify for an O1, for O1As, you have to show that you're really one of the small percentage who have risen to the very top of the field. You have a level of expertise, and there are several criteria, and I'll show you some examples that are kind of overbroad in that they don't. I'm not going to show you a list of O1A, then O1B, and then O1B motion picture television, but just so you have a sense of the basics. O1B arts, though, is a different level, so you have to show distinction. That's a high level of esteem or achievement in the field. You've been recognized as substantially above that ordinary countered. That's somewhat lower than one of the small percentage who have risen to the very top. And then we have O1B motion picture TV for extraordinary achievement, a very high level of accomplishment, evidenced by a degree of skill recognition significantly above that ordinary encountered, substantially, significantly. So O1B is motion picture TV is even somewhat less of a standard than O1B arts. But nonetheless, these are very high standards. One recommendation, which we get a lot of questions about this, especially from individuals who are nearing the end of, say, a bachelor's degree program or certificate program or any really degree program in the arts, or even in business and athletics and science and education, etc. But can I qualify for an O1 is the question. Well, that depends. Can you qualify for an O1? I don't know. It would require a case-by-case analysis to take a look at all of the documentation, which we'll go through in a minute, that you should be using during your OPT time to start acquiring. You have that work authorization. You have an unrestricted work authorization as it relates to your field. Take that and use that to your advantage and get out there and do the work and start building up your career, even if you already have one abroad, because USCIS likes to see the sustained acclaim, sustained achievement, accomplishment. Go through, take OPT time, since you can't work otherwise whenever you're an F-1 student, for example, you can't be doing the work, but OPT you can. So it may not qualify as STEM, especially in the arts, so you may not get that STEM extension. Use that year to build up. Even if you're unable to stay in the U.S. after that first year, don't give up. Continue working outside of the U.S. Or if you do qualify, and you may, it's not impossible to qualify after just 1 year of finishing an academic program. Consider that you can still build your career and credentials abroad. Or if you're already working with a collective, a studio, a production house, a company where there are O1s working, consider that you may, and you have experience working with the individual O1 or other O1s, consider the O2 option. That may allow you to continue, at least, continuing what you're doing, and as you're continuously acquiring credits, that may help. Nonetheless, the O1 criteria. So what are the things that you need to show USCIS? You can say that you're the best, but USCIS is not going to take your word for it. More often than not, the most concrete thing that you can do is to have press in major mainstream publications written by others about you. Or if you're a writer, for example, publishing in these, either main journals in your field, industry journals, trade journals, or in other mainstream media if you're literally just a writer like that, or if you're a music critic or whatever. Get these press about you in major media. The press can help meet a variety of things, but number one, it goes to show that you are, you're either internationally recognized, your achievements have been internationally recognized, or you just have achieved international recognition because of your success or because of your accomplishments. But it can also go to show the specific significant contributions you've made or specific achievements you've made. Not just that you're, known as the best, but specifically what you're known for. So-and-so published a book that was #2 on the New York Times bestseller list. Even press about that fact. Of course, we would also want the rankings of, the bestsellers list, but that's one example. Or you've done presentations in various places around the country on a specific issue. You've had critical roles for leading, starting, or critical roles for either organizations and establishments with distinguished reputations, or on specific productions or events that have distinguished reputations. The reputations should be distinguished nationally and internationally. High remuneration in comparison to others in the field is always helpful. So that can be evidenced by contracts, pay records, pay stubs. Contracts are usually the best evidence. Bank account statements, W-2s, or foreign bank accounts, or tax returns, etc. In comparison to others in the field is usually helpfully demonstrated by the Department of Labor's wage surveys, but we also like to include, some other comparable evidence, like letters from experts to verify that, I know that this person is, for lack of a better phrase, awesome, and because they're awesome, I hired them to do this project. In fact, they were so awesome that I paid them 4 times what I would normally pay someone else to do this. And in my place in the industry, I also know that that's what usually people are paid. That's just one thing. The original contributions to the field, if you've made actual significant advancements, if you've changed the way that others do work in the field, or explored a new unforgettable way that maybe a film is captured, or a graphic is rendered, or the list goes on. A new genre was born because of you. Those are the types of things that, if we can get into specifics about, or even in the business context, an invention, a discovery in the science context, a world record in the athletics context, a state record, usually helpfully if that's the country state. Membership in associations requiring outstanding achievements of their members. I could go through all of these, but I'm not. I'm going to just simply also just last mention, you can use the online press. Major media does not exclude blogs. For example, there are, in the US, published lists of the most read blogs or most visited by page numbers, unique site visits per month, per week. The actual readership and distribution info, publication distribution info, etc., is helpful to show that the press that you have about you is in major mainstream. It doesn't have to be mainstream, but it just has to be considered major, or it can be considered trade or industry. But whatever that media is, for one of those categories, you have to be able to prove it. So it's not just the piece of press that you have, the article that you have in Time Magazine. USCIS is not even going to take your word for it that Time Magazine is major. You need to get that other piece of it, the readership and distribution and reputation info of the press. So think about, if you're going to consider the O1, these types of documents to start gathering in addition to advancing your career so that you can be one of the very top, or you have a high level of achievement or a very high level of accomplishment, substantially or significantly above that ordinarily encountered. Well, I went through mostly non-immigrant visa options, and so I'm not going to go over the immigrant visa options today. I do want to give this time, so we have about 7 minutes or so left, to answer any questions that anyone in the audience has. I will take a look and see. You can use your GoToWebinar function to type in any questions that you may have, and I will address them. So far, we don't have any questions, but while that's going on, then I will talk about perhaps a little bit of the immigrant visa process. I'll skip over the family-based options, but for the immigrant visa options, we have the aliens of extraordinary ability, the EB-1 first preference. That is a parallel, or rather similar to, but not identical to the O-1. It's an even higher standard. The multinational manager, the EB-1-3, is very similar in that it is first preference, but parallels the L. The outstanding researcher and professor is a EB-1-2, is for, researchers, professors who have, specific job offers from employers in the U.S. Oh, I'm being told that we're running out of time and I have 1 minute to go. I'm sorry. The last thing is then the self-sponsored, and I'll just mention very briefly. Self-sponsored options include, for green cards, only really 2 categories. The EB-1, aliens of extraordinary ability. You do not need a job offer. You just need to be able to demonstrate that you intend to continue working in your field of expertise in the U.S. And the National Interest Waiver, NIW, which is for individuals who work as national in scope and will have a substantial impact on the U.S. nationally. And that is by you show that by demonstrating that you've done it already, either abroad or in the U.S., and you'll continue doing it. So let's see. Wait, I have a question here. What are the eligibility criteria for E3 for Australians? Great question. Very quickly, you must have a job offer in the U.S. from a U.S. employer whose job requires at least a bachelor's degree in a specific field of study, aka it qualifies as a specialty occupation. You have to be a citizen of Australia, so you have a passport from Australia that you use to apply for the visa after the LCA is certified. The LCA has to be specifically filed and approved under the E3 category. You have to qualify for the job offer, meaning you have to have at least that bachelor's degree in a specific field, a similar field, or the equivalent. That can be a foreign equivalent of a U.S. bachelor's done through an equivalency evaluation, or education experience and expertise in the field, which has been determined to be equivalent to a bachelor's degree. Experience to education, 3-to-1 ratio. So no studies whatsoever, 12 years of work experience in the field, progressively responsible, plus expertise shown through accomplishments very similar to the O1. If you have any more questions, please see my contact information at the end, and I've just ran out of time. Thank you very much.